Hello landlords, it's Ernie Garcia, your landlord attorney. Today we're going to review an episode of TV Court where a landlord has evicted a tenant, but now the tenant has come back to sue. Let's get started. All right, so let me set things up here for you. We have a plaintiff who was the former tenant, and she is suing because she says that the landlord, number one, wrongfully evicted her, but also that the landlord wrongfully withheld her security deposit, and the landlord wrongfully withheld her last month of prepaid rent. So she's suing for a total of $2,850 to recover these. So now for the defendant, this is the landlord, and he's brought a witness with him who has assisted him in the process. What they're claiming is that she failed to maintain the lawn. She had an illegal business at the time, that she left trash in the garage, and that by virtue of this illegal business, she actually caused damage to the driveway. And so they use this as a basis to withhold all of the money and refund her none of her deposit.
Okay, and why did he say that? Do you know?
Because it was new neighbors that moved in 2018, and of course they complained about my son being outside.
To who did they complain?
To the code enforcement.
And code enforcement then issued warnings to them. So what is illegal about the eviction?
The eviction was, the reason why they said it was illegal was because I did not pay rent, and I paid rent. But then he changed it once he got to court with his attorney.
That's not an attorney.
Well, that's what he represented himself in June. And my attorney,
to the court?
Yeah.
No.
My attorney verified
No, Your Honor, never.
Yes, he was his co-defender or representative, because I had an attorney.
Well, but did he say I'm an attorney?
Yeah, that's what.
Okay, so first and foremost, and this is important, landlords, and I'm not just saying this because I am an attorney, but some landlords get really, really bad advice from non-attorneys, whether it's from a clerk, whether it's from some other landlord, whether they get it from the internet. You can get some really, really bad advice that is going to harm your case. It's beginning to unravel just, how this assistant is involved in this case, and it does not look good.
Well, what happened at that contest?
Well, it was dismissed due to the terms of me moving out on August the 31st.
That's called a settlement. That's not
it was a settlement,
right.
But he said that if I didn't sue him for my attorney fees in court in June, that he would allow for us to stay to August the 31st.
So then why are you suing for attorney's fees today?
Well,
because he allowed you to stay, and you stayed a day later, and then you're suing him for the attorney's fees today, too.
The only reason why I stayed a day later was because Mr. Henry refused to verify my rental history, and I have proof showing that the place where I rented to was trying to verify rental history.
That's a problem. Get out and go somewhere else for a day.
Which is
true. You don't get to stay a day.
How
many days past the agreement did you stay?
2 days.
Oh, well, you don't get to stay 2 more days there. You got to go couch surf.
Well,
because your agreement was to stop and listen. Your agreement was to leave a certain day, and you violated the agreement.
Well,
not they violated the agreement. He let you stay there until then.
Okay, well that's
fine. And the deal was that in return for that, you wouldn't seek your attorney's fees, and yet you've come here seeking $900 in attorney's fees.
Well, I don't even.
So, all right, without getting too much into this particular settlement agreement, what we can obviously see is that in the original eviction, the parties did reach a settlement. And because they reached a settlement, each side had certain obligations. And so when the plaintiff sues because she hired an attorney to work out a deal with the landlord, but then she herself violates the terms of that agreement, it's going to be difficult for her to make a valid argument that she's entitled to recover those attorney fees, that because she breached, the landlord owes her some kind of compensation. In this case, specifically for attorney fees, and the judge is not going to buy that.
Because on his itemized billing, he's charging me $1,500 for attorney fees. Attorney fees for...
In his itemized billing, where?
This bill right here, that the reason why he's keeping my deposit.
Okay. Give me what you've got.
So this is true in the state of Texas, that when a tenant vacates a rental property, it is the obligation of the landlord within 30 days after that tenant vacates to send an itemized list of how the deposit was used. Normally, the landlord has to receive some kind of forwarding address from the tenant. I always recommend, if you don't get a forwarding address but you have an email address, to go ahead and send it by email. If all you have is the last known mailing address, which is the rental unit itself, mail it there. If they forwarded their mail, they'll eventually get it. And so you want, as a landlord, to go ahead and send this itemized list describing how the deposit was used. And in this case, he is claiming, and this is generally part of most written leases, that he's entitled to recover reasonable and necessary attorney fees. But there's a bit of a twist coming up.
You're also asking for $1,500 in legal fees on what? On the eviction?
I retained.
Why did you just point to him? You retained him to what?
I retained him to go do surveillance and try to help me solve the 9 different code violations.
Okay. When you say resolve the code violations, are you out any money because of it? Like, did they fine you?
They did not find me anything that I had to pay.
Okay.
But to get her evicted, I had to hire this gentleman to help represent me for.
He can't represent you in an eviction.
Yeah, he can.
Can you? Because last I heard, that was unlawful practice of law in the state of Florida, because I'm from Florida.
I'm not representing him. He hired me.
He just said he hired you to represent him.
But to try to resolve the problem, I think the first thing I did was...
Did you say I am representing him when you got to the court?
No. No, Your Honor.
He thinks you're representing him.
I never represented myself as an attorney.
Look at him. He's in shock. He's like, I thought he could represent me. That's what I hired him for. How much did you pay him to represent you in court?
Well, not to represent me in court, try to resolve the problem.
Okay. Yeah, now you know what the company line is? All right. What is blind? Stop. What is this blind?
Okay, so here's how it works in the state of Texas. A non-attorney can represent a landlord in certain situations in an eviction matter, but at no time can a non-attorney be an attorney. And so in this case, the landlord is seeking to recover reasonable and necessary attorney's fees, but he doesn't have an actual attorney. He has a legal representative, but it's not an attorney. And in the state of Texas, that would be okay, but you can't call them an attorney and say, I want to collect my legal fees from this individual. You can collect attorney's fees, but you can't pay the fees that you pay to a non-attorney to assist you in an eviction. Again, Texas is a little different in that they'll allow a property manager, for example, to go in and present a case in the justice court. Things change a little bit when you get to the county court level, but certainly at no point can a property manager say, my landlord or the owner can be compensated for legal fees for the services that I have provided, because that property manager is not technically providing legal services. They're providing management services. And so the theory is they're simply an extension of the landlord, an agent, a representative in an agency capacity, but not in a legal one.
Driveway repairs, which you have a hard time proving. I'm satisfied by looking at the pictures of these cracks all over the place that you really have no idea if this in fact was done by her son. But in order to keep the money for $1,500 for a driveway, you've got to be able to prove that. You got $1,500 that you're claiming for legal fees, but you never hired a lawyer.
Well, actually, if I could say one more thing.
Yeah.
If the landlord employs an attorney or is forced to take legal action due to tenant's violation, the tenant shall be responsible for all costs and reasonable fees as incurred by the landlord.
You are correct that your lease says that there's a provision for legal fees if you have to enforce the lease there. So you are correct that there is a world where if you spend money on a lawyer and or you spent money on filing fees, that's something you should be able to recoup. But the thing is, you didn't have legal fees in this case. Those are legal fees in a different case. That's the actual eviction case. So you would have to go back to eviction court with good reason and say she violated the order, she didn't get out on time, so now I want my legal fees, whatever the court deems to be legal fees. be real careful, because that judge may also not like the kind of specter smell of hiring a non-lawyer to represent you. But in any event, all right, so what are you getting? The $100 cleanup fee to get the junk out, because she admits she never got it. The $125 for the landscaping, then the $75 additional for the landscaping, that's $300. And then also, you know what's funny that you didn't list here, but I am finding that you're entitled to it. You didn't even claim for the thing that is most blaring that you're entitled to, which is the rent, but I'm gonna find that you're entitled to it because she violated the court order, the settlement agreement. So I find that you're entitled to the cleanup fee, the landscaping fee. So I find that you're entitled to deduct $300 from the $1,000, and I find that the plaintiff is entitled to $700. Good luck, folks.
So let's talk about what the court, reasoned here. Number one, the judge denied any of the claim from this plaintiff that she was entitled to attorney's fees. They had a settlement agreement in the justice court to resolve the eviction, but she violated that agreement. She stayed a couple extra days into the month of September, and because she did that, she had no viable claim that she was entitled to recover anything. Again, she made an agreement, the case was dismissed, but she ended up violating that agreement. So the judge didn't buy that part of her claim. So automatically, $900 was off the table. So then she claimed that she was entitled to recover her last month's rent. She paid for the month of August, but says she was only on the premises in the month of September for 2 days. So the question is, didn't make any sense for the court to award an entire month's rent. Well, in this case, the judge found it reasonable to award an entire month's rent for her overstaying because it violated the terms of her original agreement, and in terms of her lease agreement, it violated that term. So generally speaking, rent is owed on or before the first day for the entire month in advance, and because she violated the terms of her settlement and stayed into the month of September, the judge rightfully awarded the $950 in additional rent. So that came off the table from her claim. The last remaining element of her claim was the $1,000 deposit. And while the landlord made all sorts of claims against this tenant, including cleaning fees and trash removal and the damage to the driveway and then these legal costs, the court cut through much of that. The cracks in the driveway could not be proven. The landlord simply didn't have the photographic evidence to establish before and after footage of what happened, so he had no way to prove the damages, and he kept harping on these legal fees. But again, you cannot claim legal fees from anyone that did any services for you in an eviction or any legal proceeding who is not a licensed attorney. I've seen where sometimes paralegals do work, and sometimes just people who are not associated with the. So in this case, the court did compensate this tenant $700. Whenever a tenant brings a viable claim for a wrongfully withheld security deposit, the court can award up to 3 times the amount wrongfully withheld, plus $100, plus attorney's fees. If she had brought an attorney to this legal proceeding, she would have been entitled to collect up to that amount. Again, they were under Florida law, so Texas law would not apply in her case, but it could apply in yours. So landlords, if you know there is some dispute with regard to the lease and the security deposit and the amounts that you withhold, you better be able to prove in a court of law each of the deductions that you take and make sure that each of them is a viable deduction. Is it something listed in the lease? Is it more than ordinary wear and tear? Is there damage that did not exist prior to the tenant taking occupancy, and can you prove that? So many landlords can spare themselves a lot of headaches with just a photograph. If you take enough pictures of the condition of the property, once a tenant leaves, especially in this case where the tenant was there for 5 years, it's very possible that this tenant caused the damage that the landlord sought to keep some of this deposit for, but because he could not prove it, it didn't matter. And so the tenant rightfully made a claim to recover her deposit, and she won, the majority of her claim with regard to the deposit. The other issues I think were speculative at best. But she did prove that part of her deposit was wrongfully withheld. As always, landlords, we welcome you back. Every single week we bring new content for you to enjoy. I hope you enjoyed today's review of TV Court and how using these actual examples can help us to learn how to avoid these kinds of troubles when they pop up in our own landlord-tenant situations. I hope that if you're looking for more content, YouTube seems to believe that you'd enjoy this video on the screen. And if you see a picture of my face here, click on that picture if you would like to subscribe. Until next time, landlords, happy leasing.